Mr. Risner, you ready to go?
Yeah.
All right.
Good. I may be using the SOMO for some documents, Judge. You know, at the last hearing, counsel for the defendants talked about the narrowness of the complaint, and just to refresh that issue, what the complaint said was that we asked the court to issue an order to show cause why the records sought should not be released. And then the wherefore clause was wherefore an order requiring the defendants to show cause why the public records she has requested should not be disclosed to her. Attached as an exhibit was the letter from the client asking for all hard copy documents. That's the first category: electronic documents and metadata, correspondence, notes of meetings, telephonic conversations, meeting dates and persons attending said meetings, and emails relating to the sale, lease, gifting, development of Grand Canyon University. It's a broad request. The attached as an exhibit were, her initial letter was delivered May 13th, and of course the law says that's the date from which we start counting days when the city promptly responds. She asked to come to the office on May 16th to review the records. Nothing, of course, was provided. Then on May 23rd, she sought her counsel. At that point, she sought counsel, and the letter was sent by counsel and pointed out that the activity of the city is obviously of immediate interest to many concerned citizens, including Cruz. Your office is aware of their concern and the time sensitivity of the information. Arizona law requires responses to public records requests to be prompt. And then I attached as an exhibit the letter from on May 24th, where Mr. McLaughlin, on behalf of the city, says, as attachments, I'm including copies of public records, that there's certain other records that are being withheld at this time. So we knew that there were certain records being withheld. On July 8th, 2013, the city files a motion for a protective order. And the city says the city has now fully responded to plaintiff's public records request, except that it has withheld approximately 7 documents from release. So we're in a situation at that point. We have a broad request. The city has provided some documents, and the city says we fully responded. And that motion and that statement was within the context of a motion for protective order, which the court granted prior to prior to my time to respond to the motion. The court granted it presumably because the city had said we have fully complied except for those few documents. I handed the clerk earlier, and I handed counsel a case, Phoenix New Times versus Arpaio. This is a 2008 case. There's a lot of Arpaio cases. He's someone who I guess doesn't like to turn over public records, but there's some rules in here that I think facilitate us as we facilitate my argument, certainly, but are the important rules. One, it's paragraph 12 here, it says, they point out that Arizona doesn't have a waiting period like some states. People are often familiar with FOIA requests of federal government where they have 10 days to respond. But records the response must be prompt with actual productions of the documents. And the statute, again by statute, says that the party that does not receive a prompt response, then the access is deemed denied. It goes on to talk about prompt, meaning quick to act, requested without delay, and it says,
paragraph 14.
yes. In paragraph 14, it says, whether a government agency response to a wide variety of document requests was sufficiently prompt will ultimately be dependent on the facts and circumstances of each request. And this is actually, I think, an area of the law that's of some interest, because as the court's aware, the law certainly is in Arizona that the reason for the request, isn't particularly important, but it is in terms of promptness. And the case, even this case, talks about how you look at all the facts and circumstances. If, for instance, a request goes into the county treasurer for some documents, the assessors, and then happens to be a very busy time in that office called checks are coming in, it's tax time or something, they can look at it and say, how important is this request? How many documents do we have to give? And can we delay this later and let people know, look, it happens to be busy right at the moment. This thing, it's an important issue because when this request came in, and the city the very next day set, once they got this request, they set an executive session. It was an issue where it was under active consideration, and it was a request that they knew was from a person who was representative of a coalition who was supported by 12 other groups. They knew that this was a time-sensitive request involving information that was quite important of an issue in front of the city council. In paragraph 15, another point is that Arizona law places it on the agency, in that case, the Maricopa County Sheriff's Department, the burden of establishing that its responses were prompt given the circumstances surrounding such requests. 16 says further, when public records are requested from an agency, the agency has the burden of establishing that it adequately searched for them. An agency must make a good faith effort to conduct a search for the requested records. At all times, the burden is on the agency to establish the adequacy of its search. In discharging this burden, the agency may rely on affidavits or declarations that provide reasonable detail of the scope of the search. This isn't a lawyer standing up and saying, hey, Judge, gosh, nobody takes notes at city meetings, nobody has agendas, we just kind of, meet in the hall stuff. The city has a burden, and they fulfill that burden with affidavits and declarations. As I showed before in the letter that I sent, I talked about the importance of prompt and the time sensitivity of the information. Mr. McLaughlin, there was an interesting moment when Tina Pacheco was testifying, and I asked her at the last hearing, are there entire categories of documents missing? At which point, Mr. McLaughlin says, objection, Your Honor. How do we know they're missing? How do we know they exist? Paragraph 48 of this case says, as discussed with respect to the saving request, one of those involved in the lawsuit, the burden is on the government to prove the non-existence of requested records. And in that case, the Sheriff's Department had not met that burden. The evidence, since the evidence that's in front of the court that we have on what the city has done is contained in the portions of the 30B-6 testimony, which is an exhibit. Right now, what I want to do is look at certain portions from the deposition of Christopher Kaselemis, who was a designee of the city of Tucson. And I, asked him if he understood that he was testifying on behalf of Tucson. And I have page 5, line 7. Let me ask you, have you made efforts to know the efforts of the city of Tucson in responding to the request of Mr. Miranda, the city manager, and the city clerk of the city of Tucson? I believe I'm aware. I'm aware of our efforts. He says, I understand that when we get a request like this, we check with our IT department to get all the computer files. And I met with Mr. McLaughlin several times. We've gone over. I've given him my notes and all my records, and I know he's done the same with other people who've been involved with this effort. And this question that he was responding to was all efforts made to identify public records and other matters from May 13th until July 23. So prior to July 23, prior to the statement that all the records had been turned over, the evidence from the city is that the city had all the notes, that he had met several times with Mr. McLaughlin, and furthermore, he says, page 6, I believe we started immediately. They asked us to turn over any records we have, papers, any documents, any electronic files, anything pertaining to the request, they asked us to be responsive to. Who else was asked? People in my office, Hector Martinez, Mr. Miranda, Albert Elias, and and he didn't list more, but other people. So he says they asked us to comply and to turn over to him, Mr. McLaughlin, who was handling this role for the city, everything we have, start getting stuff together. He says, they ask about IT, he says, I know we got some stuff from IT directly. Page 24, I handled personally these documents with Mr. McLaughlin, but I did deliver them. He says, and what were your documents? I had a couple of folders. I had stuff from Grand Canyon, stuff from TREO. I think I had some meeting notes. It was a compilation of, a substantial amount of stuff, various types of stuff, from working on a project that you would expect to see. How big a group of documents? Well, maybe 30 pieces of paper plus booklets and stuff from TREO. None of which were provided prior to the trial. I asked him, do you maintain a calendar when you meet with people? Yes, I do. Would you have written written on that calendar. If it was a scheduled appointment, many times I meet with people and it's not an appointment. But, okay, so at some date, then prior to July 23rd, all the documents in your file had been available to Mr. McLaughlin. And, do you know if anyone else in your office, if there was a similar process to it? Yes, I believe we do. Who were these people? Well, I believe he met with Camila Bekat from my office. I'm not sure, but if he met with Andy Squire or not, but he may have talked to Andy. So the testimony, the evidence is that there was a massive accumulation of data, discussions with all those individuals, all prior to the 23rd of July. And this motion that we've made is a motion under Rule 60C for the simple fact that these important documents weren't turned over and indeed haven't been till today. There was a part of the 30B6 was a deposition of Donald Parslow on behalf of the city of Tucson. Don Parslow is the deputy director of the Tucson Information and Technology Department. Asking, are you prepared to testify on behalf of the city of Tucson? Yes. And he says, so the first of these relate to efforts made to identify public records and other matters requested by Cecilia Cruz from May 13th until July 23. He says, I can answer that. Okay, what then was the involvement of the IT department and starting on what date and what did you all do? He says, so if we're still referring to May 13th through July 23rd, yes, answer, IT did not have a role at that point. So nothing, IT did nothing during that period of time. Yes, sir. On page 7, starting on line 10, okay, when did the efforts, when was the IT department first involved? So the first time I'm aware of that we knew about a request, was on August 15th of 2013. So question, so as to item 4, all efforts made to identify public records and other matters requested by Cecilia Cruz from July 23, 2013 until present, and by whom those efforts were made. So are you prepared to describe any efforts by the city of Tucson prior to August 15th? Answer, prior to August 15th, I have nothing to report. Page 17 of the deposition. Mr. Parslow was talking about he had received a consolidated, starting on page 16, but the city attorney, you'll see later, never gave Ms. Cruz's request, but they gave him a consolidated request. And I said, okay, what was the request and the criteria that was made to the IT department? Is it the actual criteria? Yeah, I can't recall that. What was the request? So he answers, so basically, okay, let me be clear about this. If it's an email request, which is what we were asked to do, then it's the accounts to search for, the terms of the search, and usually the date range of the search for. Question, okay, so there was a request that came for search terms, account names, or accounts. Answer, email accounts. Question, and terms, that's like a Boolean type search. Well, terms, that would be like words to pick out within email part of the search, and a date range. some sort of date range. Okay. Question, but you don't know what those are. You're not prepared today to say what the request specifically involved, what the terms specifically, no, sir. Or email accounts for anything, no, sir. Ask page 19, what was the date of that request? Answered the first one from my notes, this is the first request from the city to turn over documents that the city at the deposition wasn't prepared to say what the terms were, what they were looking for. But the first one from my notes is on September 12th. Question, so on September 12th, that was the request from the city attorney's office. Yes, sir. Going to page 60. And when you found emails, all of those emails would have had to, from date, subject, etc. Yeah, if CCs were available, yeah. And when they have attachments, correct? They should. So when you retrieve all those emails, you're retrieving all of those, that information in each of those emails. Yes, sir, on an individual basis, we retrieve what you see there, either saved out into a file, and that's given to the city attorney's office. Page 65, question line 1, but if you had been asked to do that, then you actually could get the complete emails for each of these individuals. Answer, it depends on the timing. If those were older than what was on the tape then, I couldn't get those from you, but anything that was in the system when we did the search, we could provide. Going to line 16, so the answer continues. So when we have to search a time that we can't get to through the live system, we have to go restore a post office and do the search in that post office. So what's the time limit on your live system? Well, the time limit on the live system, I believe, is 90 days it starts. It starts putting things into trash. And then trash, I'm not sure, it holds that maybe 7 or 14 days. Okay, but even at that point, you can go into the post office and find the documents. If they're there, yes. Yeah, and for what period of time can you go back and find those? It depends. We usually have a rotating time amount. It's usually another 90 days. And then what happens to them? The tapes rotate off and get overwritten by another backup. Question, so after 180 days, then documents can be disappeared permanently. Answer, yes, sir, unless they're printed out or saved in a file or something. Page 74, question on line 11. So when you're searching the email, do you know what time period you were searching for? No, I don't. I don't recall that. It was part of the criteria, whatever was sent to us. Page 76. Question, so would you be able to find any emails from January or February 2013? Just looking at the parameters we discussed, I wouldn't think we'd be able to do that.
Your Honor, can I just note here, your minute entry noted that this was for argument, and I think we're continuing an evidentiary hearing here, which really wasn't noticed to me. So I wish we could get to argument.
Well, Mr. McLaughlin, aren't all these documents in front of you as an exhibit?
They are.
In closing arguments, lawyers routinely point out evidence that they say supports their arguments. So I'm going to overrule that objection, and you've had the same notice Mr. Risner's had, so you can go ahead and
Thank you.
make your arguments then.
Thank you.
Page 80, question was, so 924, why didn't the city provide metadata as requested? You know, I can answer 81, line 1. I don't speak again to the IT portion, yeah, but the metadata, at least in the document I saw, was not requested. Oh, going to page 82. Okay, but to be clear, the city attorney's office never informed the IT department that Ms. Cruz had requested metadata in her May 13th, 2013 request. Answer, as far as doing this request and as part of the request, no. The, in Exhibit G that the city introduced last time was an interesting email. This one initially, starting at the bottom of it, is from, this is dated February 19th, 2013. It's from Josh Brodesky, the Arizona Republic. So it's the largest newspaper in Arizona, asking for, under the public records laws, all records connected to the proposal to Grand Canyon University about a possible campus. This includes, but is not limited to, documents such as reports, memos, and emails. The Arizona Republic, in its request, says, I strongly believe that the foregoing documents are a matter of public record and are of vital interest to the public because they involve the behavior of employees. Since this information's value diminishes greatly with the passage of time, I would appreciate your communicating with me by telephone. Then there's February 19th. Brodesky says, thanks for talking to me by the telephone, and again talks about what he's looking for. And then on January 20th, 2013, the city employee Mike Randall sends an email to Mike Rankin, the city attorney. Hi Mike, below is Josh's public record request. Let me know if you need any further information. The city provided no information to the largest newspaper in Arizona, just like they provided no information to the key information to our client.
Your Honor, I object. There's no foundation for that statement. There's nothing he said indicated that we gave no information to Mr. Brodesky.
I'll sustain that objection.
Well,
Has there been, maybe I'm mistaken, there's been quite a bit of evidence in this case. Has there been evidence in this case, other than the assertion you just made, which is not evidence, that no response was made to Mr. Brodesky's request?
Well, we've had discussions. Mr. McLaughlin is aware that Tina Pacheco told him that she talked to Josh Brodesky and he got nothing. And the city's fully available to put on evidence that they did comply with it. Or let's look at it another way.
Okay,
But I don't.
I'm going to sustain the objection. Ms. Cruz's document request is the one that's at issue here, and there are a lot of issues to discuss about that one. So let's move on.
I think a couple of points. One is certainly on the issue of bad faith. The court needs to understand that we were prohibited and greatly limited on any sort of discovery in this case to even
well, let me stop you. Mr. Risner, Exhibit E is in evidence, correct?
Yeah.
Is that right, Mr. McLaughlin?
Your Honor, actually, I'm not sure that I formally put Exhibits A through G into evidence, and at this point I would offer them in evidence to make sure of that. He's already referred to it. I have no problem with that, but I would like it in evidence.
I assume you want them in evidence, Mr. Risner, if they're not already?
Sure.
All right, A through G are admitted. The fact that E is in evidence and E exists is something that I can consider, and I can consider its evidentiary value that before Ms. Cruz's request, which I believe was in early May, there was a request much earlier made by Mr. Brodesky, which really indicated that somebody had interest in all of this and was interested in seeing records, and if that's the evidentiary effect you wanted to have, I can tell you that it does demonstrate that there was interest as early as January, apparently. So, February, excuse me.
Yeah, sure, and it's a vital interest because of the time, and I would say there then are two possible responses to that. One is the city in fact accumulated the documents and records that the Arizona Republic had requested for, which would greatly have facilitated their response to my client if they had done that. If they did what they're supposed to do, it's not helpful to the city. We think they didn't do anything, but we don't have available evidence to show that. The city was certainly aware of my client's assertion of the time importance of getting these documents. This is an email from Dennis McLaughlin to employees in the city manager's office. I believe Ivana Espino may be the public relations person there. Nicole Ewing Gavin was working on this project. And then he says, referring to Ms. Cruz, or has CMO, okay, that's the city manager's office, contacted this requester yet. She is now calling us regularly, coming down to view records, quote, as time is of the essence, quoting Ms. Cruz. So the city was certainly involved, aware of the time is of the essence. We recently received some documents that show a little more of who was involved, and I believe this is part of the exhibit G. The testimony from city manager was that he had put Albert Elias in charge of this project. So this is a letter concerning, and this is February 8th. Rebecca, I believe she may be a secretary in the for Mr. Elias, but she is sending this to Albert Elias, Nicole, Chris Kaselemis, Tim Murphy, about a meeting requested by the city manager.
Carol, would it be possible to cut some but not all of the lights? And
Yes.
would that mess up anything for anybody else?
We can have this one or we can remove this one.
Cut them both and see what it does. Is that still workable for everybody?
Yes.
Because that does actually help me and takes the glare off a little bit. So, okay, go ahead, Mr. Rice.
Yeah, this is an email again the city gave us that's part of the exhibit. Strangely enough, in March 2014, it was taken from the computer and printed out. But this is from, but it's from the 21st of February. The Brodetsky request was February 19th, and as Mr. Brodetsky had pointed out, it was because there was an article in the newspaper that Grand Canyon was considering this that triggered their interest. And again, it's Kaselemis, Albert Elias, Kelly Gottschalk, Assistant City Manager Liz Miller, setting a meeting about TREO and First Key. Later on, the initial email here had high priority. This was an important thing. We received that recently as a result of the city responding to a specific request, asking for that. Also, as part of G, this is a February 22nd, and we can see who the key people are of the working group on this thing. Albert Elias, Kelly Gottschalk, Liz Miller, Mike Rankin, Nicole, Ewan Gavin, Richard Miranda, similar individuals. The 22nd, we've got Elias, Gottschalk, Miller, Cole, Ewan, some more, but we don't know who the rest are because that was cut off. On the 27th, says council informed. That's interesting. Grand Canyon City Council. 27th of February, again, Elias, Gottschalk, Miller, Nicole Ewan, Gavin, Richard Miranda. There's a note from May 17th, communication next steps on Grand Canyon University, Albert Elias, Andrew Greenhill, from, I think it's the mayor's office, I may be wrong, Andrew Squire, also Kelly Gottschalk, Mike Rankin, Nicole, Richard Miranda. I have marked as an exhibit.
When were the February emails produced?
That was produced the weekend before, the Saturday before the hearing on, 8 days ago. So, and,
Yes. Hold on.
You're asking here, which?
Well, I'm talking, you just had a discussion, the first question I raised about was Exhibit E, and then there's been a discussion since then about emails, which I'm assuming are part of Exhibits A through G, which were just admitted, and all of which are in this period of time, appear to be within this period of time, well before Ms. Cruz's document request, and I'm wondering when those documents were produced in connection with this matter. And Mr. Risner, you say it was about 2 weeks, less than 2 weeks ago, is that correct?
yeah, I'd say I got it, emailed it Friday afternoon, I got it Saturday.
Your Honor, do you mean some of the listing of who got them or the email itself? Because I need to research. I believe the email itself about council informed, for instance, was released
What I mean
at
is,
some point
hold on,
earlier than that.
Hold on, Mr. McLaughlin. What I mean is, when did Ms. Cruz, through her lawyer, Mr. Risner, receive those documents?
If you mean Exhibit G, she received them March 21st. But they
Of
are
2014.
Of 2014.
March 21st
Right.
would be before her 2013 request.
But they refer to documents that were released to them before that. It would depend, we'd have to go document by document. In other words, the council informed document may have been released to her as early as last June. I'm not saying it was or wasn't, I don't know, I'd need to look at that. But this is supplemental to the email itself.
All right, Mr. Risner, go ahead.
Yeah, I have marked as Exhibit 11, which I would offer. It's a list, no, it's just complete, of 20 people that I believe are part of the sort of work group that were involved in this project. And we have no paper files, no calendars, no notes from those people. We have some notes that we've gotten from Hector Martinez, very limited, I think this one sheet, but none, but otherwise, nada. So for 60C purposes, the whole key of stuff that explains what's going on with this deal, we have not yet received.
Are you offering Exhibit 11,
Yes.
Mr. McLaughlin?
I don't object for the limited purpose of it showing what they claim they don't have. I do object if they're claiming to prove from this that these exist and they don't have them. Because in many cases, there won't be a paper file. There won't be notes. What I would say is I'm glad to take this list and go ask people, but if he wants Exhibit 11 to say, this is a list that I'd like you to go check, I'm happy to have it admitted.
I guess I've got two responses to that. Obviously, the list doesn't say who's got what.
Right.
The list identifies who might have what, or who might have something. I'm gonna admit the list, 11's admitted. But I have to tell you, it's the second time or third time in this hearing, I'm a little surprised that at this late juncture, this far into the matter, that you don't seem to know who's got what, and what's been produced and when it was produced. I would think you'd be aware of that at this point, Mr. McLaughlin.
Well, Your Honor, I'm sorry, I'm dealing with 2,700 documents. I am aware generally of what's there and what isn't there. It's my belief that if these have not been found, they don't exist, but I'm checking on that. So my position on 11 is I would say I will check, I
All
don't
right,
know.
well, you're gonna get to argue, so.
Sure.
11 has been admitted, Mr. Risner, go ahead.
Yeah, the last time we were in court, Mr. McLaughlin talked about a meeting on February 6th, where he says, the city says, give us a list of what you know we have that we haven't given you, or something like that. There was that.
That's not how it's said.
Hold on, Mr. McLaughlin, you get a chance to argue. Don't interrupt, please.
So that was on February 6th. At the end of that meeting, it asked McLaughlin that I wanted to personally meet with him. And here's on February 10th, I said the judge had directed we meet. I'm available. So we met 2 days later. On February, and at that meeting, we discussed the evidence at the hearing. I told him what evidence I wanted to put on. We discussed the time. We agreed that we would each have 90 minutes. He didn't know what evidence he wanted to put on, but I told him I wanted to put on evidence. And I told him at that meeting that he would be subpoenaed, that I thought he had, since he had interjected himself as the person to accumulate all the records, that he had valuable critical information about what was done at various periods of time. So he then later, as Your Honor knows, filed a motion asking that that I be required to file a motion to disqualify the entire office. I want to do that because I don't want this thing to go on forever. We're focusing where we want the documents, so I said that I wouldn't call him, and that was what I put in writing. So when Mr. McLaughlin says that he was surprised there was evidence, there was going to be evidence offered at the last hearing, he was fully aware because he knew that he had been was to be called as a witness. And this is on the 13th. And in the 13th, I pointed out to McLaughlin that your requested remedy for the plaintiff is for us to guess which records might be missing without the city complying with its V6 obligations.
Excuse me, Your Honor, is this in evidence? I don't believe it's in evidence.
Oh, all right, let's move on, Mr. Risner.
Okay, let's move on to then what is very much in evidence. Mr. McLaughlin talked about how he was surprised that instead of us playing the sucker game that I told them that we wouldn't pay, that we wanted them to comply with their legal requirements. In the reply on March 4th, on page 6 of the reply, I pointed out that the defendants have not produced, at the bottom of page 4, notes from Richard Miranda, Albert Elias, notes from others who worked on the project, such as Camila Bekat, Nicolio Giving. Kaselemis testified that Liz Miller may have actually written the offer letter, but we don't have information from her. Then I point out Exhibit 8 to plaintiff's motion for a new trial, dated December 16, 2013, is a declaration from Christina Pacheco, which discusses missing records. Attached as Exhibit 1 to this reply is an updated review of some of those known missing records prepared by Ms. Pacheco. It is included for illustrated purposes. So what I told them in writing was, we know that there are the files from these additional people, that's the key stuff, that's what we want, and we want you to follow the law. And what we're attaching for as Ms. Pacheco's, what she's pointed out that we know is missing is just to illustrate there's a lot of stuff that we know is missing, but this is a game that goes on and on and on and on and on, which the city fully understands because of Mr. McLaughlin's very objection to Ms. Pacheco's testimony of how do you know what you don't have? So this motion then I think is relatively simple. Rule 60.
Your Honor, I object again. We're arguing attorney's fees, not Rule 60.
Yeah, we're arguing all the pending motions, Mr. McLaughlin.
Rule 60C, and I've cited the case of the, you know, it's fairly broad. It says even inadvertently not turning over important information can qualify for a new trial. What the city's position here is,
Look, let me stop you, Mr. Risner. What does a new trial do? Does Rule 60C enable me to amend, and I'll ask the same question, Mr. McLaughlin. Rule 60C is a motion, the scope of which is pretty broad. Does it permit me to amend the judgment back in July? I think it wasn't in July, I think it was in August, early August, and maybe when, on the first ruling after the trial, to encompass the entirety of the response, the entirety of the documents requested in Ms. Cruz's original May request.
sure,
Doesn't that do the same thing as a new trial?
yeah, exactly. That's why I believed my Rule 59 motion was good because the court had enabled us to take a 30B6 motion, so therefore it wasn't, you know, final. That was my belief. That's why I filed a Rule 59 motion. But if the Rule 59 motion was untimely, then the 60C motion is timely. So either way, we're back at the same spot. It's when we didn't get a fair hearing or fair trial, and the reason is we were cut off at the knees on discovery because the city said, protect us, we've turned everything over. And it absolutely isn't true. And based on the conduct of the city at this point, we don't want to be in a situation where Mr. McLaughlin says, hey, I talked to this, he said he doesn't have any. I talked to this person, he doesn't have anything. I need the ability to get some people under oath and say, what documents did you have? Did you have a file? What's in it? What did you do with that file? Now, it's true that that should not be necessary. It's true that the city should fork over the documents and give us the ability to simply test whether they've done all of it. But this is a situation where it's clear that the city has drugged things out in terms of promptness and hiding things, where they first, on September 12th, asked the IT department for documents and show up at at a 30B6 deposition, so, well, I don't know what the criteria was, I don't know what I was asked for, I don't know what we did, things have disappeared. It has to stop, and the way that it works in our legal system is to get people under oath, to utilize the system of discovery, to utilize the system of asking people, what did you do, what did you go to the meetings, and so forth, and what went on. Because a mere statement, not evidence produced. We hear statements from the lawyers saying, well, nobody keeps calendars, nobody takes notes. We just, the first time we've ever sold an existing city property, $100 million here, big thing there, 60-year lease, huge project, zoning, meetings with all these people. Hey, you know, we don't have these documents. Maybe they don't have them. Maybe we find out that it's absolutely true. Then the public knows how they do business, which is part of the public records laws, is to find out how things are done and who's doing what, because these are public assets, public employees, and all public records and other matters in their offices are open to disclosure and need to be turned over to people if they're requested. She requested it, they got them, and we didn't get them. And they can't say, our lie schnookered the judge, and they came in here and told you that they had turned everything over, told you that the only thing they had in left, and told us the only thing we got left is in these envelopes. That's why there has to be a new trial, and either it's absolutely conscious behavior on their part, or giving them all these benefits. Gee, it's just inadvertent, they didn't know all these stuff. Fact is, they haven't turned them over, and we have a right to them.
Mr. McLaughlin?